Okay, I'll speak to number 9 and 10, so amendments in my own name. On Amendment 9, there's an important history to this amendment. There is an important question about the entitlement of the Dáil and Shannon to know what precisely they are legislating for. For far too long, this question has been hidden in administrative omerta and legal obfuscation, and the law, as understood it, has been ignored and unenforced. The issue I refer to is the status of private members' clubs under the Gaming and Lotteries Act 1956. Various venues, now a stone's throw away from this building, have operated as casinos for decades now, under the pretext that they are immune from the law because they are private clubs that are open to members only, even though membership can be bought at the door. There are substantial amendments to the 1956 Act in 2019, and in the course of debate on the Gaming and Lotteries Act Amendment 2019, the question arose as to the impact of this bill on the operation of those private members' clubs. It has been stated by successive Ministers for Justice that the 1956 Act doesn't apply to clubs. Sometimes the argument has been more narrowly made that the Act does not apply to bona fide private members' clubs. In reality, of course, the clubs advertised around town are proprietary clubs, not members' clubs, and are run by their owners as commercial operations. The reason the question is important is that these venues offer casino-style games such as roulette and blackjack. A casino game is defined in law as one where, by reason of the nature of the game, the chances of all the players, including the banker, are not equal. Promoting casino-style games is unlawful under Section 4 of the 1956 Act. Up to recently, it was generally hard to know how or why the 1956 Act was even interpreted as not applying to these venues. As far as I know, there is no judgment of a superior court in the question, and the state has never appealed the case and sought such a judgment from a higher court. As was pointed out in the Regulation of Gaming in Ireland, the report of the Casino Committee 2006, the provision of casino-style games in these clubs should be a matter of concern, given that it is entirely contrary to the intentions of the 1956 Act, and there can be no regulation of this activity. But if that Act is in fact defective, no minister has ever spelled out to the Dáil what precisely the defect is, or why the defect has never been remedied. We do not even know if this defect is thought to cover both members' clubs that are owned and run by the members themselves, and also proprietary clubs that are owned and run as commercial operations. However, in the course of the debate of the 2019 Amendment Bill, matters were placed on a different footing. In the Select Committee on Justice and Equality on the 10th of July, in reply to an amendment seeking to insert a definition of private members' club, Minister of State David Stanton said that the existence of such clubs rose on foot of a constitutional protection, that members' clubs were not governed by the 1956 Act or by his bill, and that thus, according to the advice of the Office of the Attorney-General, there was no need to accept the amendment. The Minister declared that there was constitutional protection for private members' clubs. At report stage in that bill in the Dáil on the 4th of November, the Minister said, "I have made this point repeatedly, that the operation of such clubs enjoy a constitutional protection, that of free association. Those clubs are not governed in the context of gaming activities by the Gaming and Lotteries Act 1956, by this bill, or by the enactment of law. This position is supported by the advice I have received from the Office of the Attorney-General. I went there to be sure to get that advice." End quote. So on the Minister's understanding of the situation, we could sit here and legislate to abolishing gambling entirely, but if all of us have decided to form a club under the Constitution, we can go away and engage in gambling. This is an astonishing proposition. I've discussed it with lawyers and they are equally astonished. It leads to a bizarre, nonsensical and unacceptable conclusion. Are we meant to believe that the Oireachtas can legislate against misuse of drugs, for example, but that opium dens should be exempted from the law so long as they charge a membership fee at the door? Or that clubs in St Stephen's Green can constitutionally ignore the liquor licensing laws? I believe this interpretation of the Constitution is not only unsustainable but downright foolish on its face, and its foolishness can be seen from the fact that even the gambling industry itself does not accept it, because the Gaming and Leisure Association of Ireland helpfully circulated to DDs an opinion that commissioned from David Collins-Smith SC. I've copied it here. That opinion concludes that there was no unconstitutional inference in the 2019 bill with the rights, interference with the rights of the members of private clubs to associate with each other. The legislation instead proposed to limit in the public interest gaming activities in and of such clubs, and in the opinion of Senior Counsel, the legislation should be defended by the Government as regulation and control in the public interest of the existence of the foregoing right, as referred to in Article 40.6.1 of the Constitution. So we have a situation where the Minister has interpreted gambling legislation as not applying to private members' clubs because of constitutional rights of their members, while the clubs themselves have been legally advised and believe that they cannot assert any such right. I don't know of any other area where we as TDs are asked to legislate on an understanding that the laws we pass will not apply to a certain sector because of an assumed constitutional bar that is nowhere referenced in the law itself, and where the sector itself does not assert any such constitutional immunity. At the very least, we should have the sight of any advice on this question from the Office of the Attorney-General. We cannot be asked to legislate blindfolded. As members of the legislature, we are in an impossible situation. There is already legislation in force aimed at outlawing certain commercial activities. However, even though the Act does not explicitly exempt a certain sector, the law is not applied to that sector. When the Dáil was asked to amend this law in 2019, we were told that any law we passed would not apply to that sector either, on constitutional grounds. But the sector itself disavows any such constitutional entitlement. We need to know if the Government is still insisting, in the context of this bill, and despite the legal opinion we have seen from other quarters, that the constitutional recognition and protection afforded to private members' clubs exempts them from compliance with gambling legislation. And if the proposition is unattainable as a matter of constitutional law, which I believe it is, then we need to know where this crazy notion came from and how it has been maintained in place for so long and so profitably. In terms of Amendment number 10, Las Concordia, this amendment excludes charities from the Act. Charities should be regulated by the charity regulator. They are not and cannot be considered to be commercial gambling, and this Act is very much directed to commercial gambling. UK Gambling Commission research showed only a small minority of people believe charity fundraising lotteries or draws are regarded as primary ways of donating, not a form of gambling. Those who do see them as gambling see them as the least harmful form of gambling. The bill has exempted the National Lottery, so it seems consistent to allow the same logic apply to charities as to the National Lottery.